Good afternoon. Welcome to the third Tanfield Talks. Today, Will Beetson and I will talk on forfeiture and the impact of the pandemic. There'll be a quick Q&A at the end, time and knowledge permitting, so feel free to post in during the talk. Afterwards, any queries you have or feedback, you can email events@tanfieldchambers.co.uk. Just a little trailer for next week. Same time, same place, Mark Loveday and Gemma de Cordova will be dealing with opposition grounds under the 1954 Act. That sounds like a fairly COVID-free environment. Unfortunately, not today. For now, we will get on with forfeiture or not, as the case may be. So, to provide you an overview of the talk, we're going to review the current landscape on forfeiture as affected by the pandemic, and then deal with issues of waiver and relief. So, the law of forfeiture. Complex, it lacks coherence, and it can lead to injustice. That's what the Law Commission said about it in 2006. They advocated for its abolition, but it's remained as a constant in the property litigation landscape before that and afterwards. And in fact, it's taken a pandemic to temporarily at least stop it in its tracks. Maybe it'll turn attention to long-term reform. So what's happened to forfeiture in light of the pandemic? The current landscape on forfeiture has been impacted directly by four significant pieces of legislation. And we'll deal with those in turn, although most of you will no doubt be very familiar with them already. The Coronavirus Act, Section 82 in particular, the Civil Procedure Rules, PD 51Z, taking control of goods and certification of enforcement agents regulations, that deals with CRA, the Commercial Rent Arrears Recovery, and finally the Corporate Insolvency and Governance Bill. So we'll just briefly take you through those to give you the backdrop as to where we are now. So firstly, Section 82 of the Coronavirus Act 2020. Importantly and directly in relation to forfeiture, it provides there's no right of re-entry or forfeiture by action or otherwise and can be enforced for non-payment of rent until the 30th of June 2020. And this is in relation to business tenancies, and that's all business tenancies. There is a reference to the Landlord and Tenant Act 1954, and most of us are used to that in the context of protected tenancies, but it's all tenancies protected or not. It's also worth noting for now that it's the enforcement of a right of re-entry or forfeiture that's prohibited. Another point of importance that we'll return to later on, and in particular Will would deal with, is there's no waiver of the right to forfeit until the 30th of June 2020 in relation to non-payment of rent, unless there's an express waiver in writing. This opens up, as we'll see later on, the ability of the landlord and tenant to come to some alternative arrangements in the meantime. And again, another point worth noting, that nothing in Section 82 prevents the rights of rising, the forfeiture from arising. It's just enforcement that is restricted. The next piece of legislation is the Practice Direction 51Z. This applies not just to business tenancies, but also to all residential tenancies as well. All CPR Part 55 possession proceedings and all proceedings to enforce are stayed for 90 days, as most of us are well aware. It stops all the proceedings in its tracks. So whereas the Act dealt with just the act of forfeiture, Section 82 dealt with that, this is the procedural side, which is far more wide-ranging in what it stops. The stay that is imposed will only be lifted in exceptional circumstances, and we have the recent case of Arkin and Marshall for clarification on that, where the Court of Appeal posited that the exceptional circumstance would be something like where in fact the stay is going to cause the virus to spread. Another and what became clearer reason for the stay was to take the load off the county courts as well at a time when they're under increasing pressure. So one of the things you can do though is you can issue proceedings, and that would include issued proceedings from forfeiture. But query whether you can serve a claim form, because that would affect forfeiture and whether or not that would be caught by Section 82. The third piece of legislation is in relation to the Commercial Rent Arrears Recovery. There's a couple of significant points here. The first is that from the 25th of April, instead of 7 days arrears needing to be outstanding before a landlord could exercise this remedy, 90 days rent have to be outstanding. That's a quarter. Tenants will be in difficulty on this if they've missed the March quarter, for example. All they'd need to do, though, is to bring the amount of arrears below the 90 days. They don't have to clear it off entirely. There is some give in relation to the landlords on this, in that the time limits have been extended for existing notices by 12 months. So they'll have, normally the notices have a 12-month lifespan, and they'll be able to rely on older notices, hopefully after once the relaxation has come into place. And finally, enforcing goods and commercial debt recovery, where the goods are on residential premises, has been limited. You can't remove goods from residential premises. The justification for that would that would breach social distancing. Finally, we have the Corporate Insolvency and Governance Bill. This is relatively recently been put forward, and indeed today I think it's going through the second reading in the House of Commons, so it is relatively up to date in this ever-changing landscape that we are faced with. It's of general application. It's not just in the landlord and tenant sphere, but it is of particular interest for landlord and tenants. And indeed, the changes, or the particular points I'm about to deal with in the bill, were trailed by the government in a statement on the 23rd of April 2020, in which they sought to tackle what they termed aggressive rent collection. They had initially touted that statutory demands would be temporarily voided, but instead that's translated into the draft legislation as preventing any winding up petition from being presented relying on a statutory demand that was served between the 1st of March 2020 and the 30th of June 2020. That later date may be changed later on, depending on when the Act comes into force. It also prevents any winding up position from being presented unless what's known as the COVID condition is satisfied. There are two COVID conditions. Firstly, the petitioner has to have a reasonable ground for believing that coronavirus has not had a financial effect on the company. That's a relatively low hurdle, a low threshold. It's be hard to find any sector that hasn't had a financial effect. The second, though, is probably going to be the more contentious one. It's that the petition would have arisen, the ground for presenting the petition would have arisen in any event. And you can see that really what the focus is on trying to preserve companies that, but for the coronavirus, would have continued, but not to save those that were struggling in any event. Given that the bill hasn't been enacted yet, and almost with an eye to preventing people taking precipitous action before that happens, and there's also provision to restore companies to the register if they have been wound up, but the COVID condition would not have been met. And finally, a short-term moratorium, a light touch moratorium, is being proposed for companies who are unable to presently pay their debts, but are likely to be a going concern. Of importance, though, is this doesn't provide any rent holiday, something that many of the letting sectors have been asking for. What it does do, though, is whilst that moratorium is in place, the landlord cannot forfeit or use CRA. So just stepping back slightly then and seeing what the implication of those four strands of legislation are on forfeiture. Firstly, none of them provide for any statutory rent or service charge holiday. Given that most tenants then, or a lot of tenants, are unable to derive any income from the premises and have been for a while, there are going to be increased arrears, and the landlords are obviously looking in order to recover those. The landlord's methods of enforcing and recovering those arrears, other than forfeiture, have been limited. Insolvency measures, limited CRA. They could seek a money judgment, but again, the enforcement of that is going to be limited. All of that then puts added pressure on the landlord, who would reach for their usual method of ensuring payment by forfeiture. But that's very limited now, particularly in cases of non-payment of rent. Landlords may look around for potentially for other breaches that they could enforce, but even if they do find those, that's only possible by peaceable re-entry. Again, I mentioned this earlier, there's no waiver unless it's expressly put in writing that there's a waiver in relation to non-payment of rent. So it's an attempt to put matters off for the future. And again, this is something that we'll pick up in a moment. And finally, landlords can still avail themselves of a rent deposit, but they need to think about that carefully, particularly if the company is going into administration and they wanted to claim that period of rent as an expense in the administration. So now I'm going to try and smoothly hand over to Will, who will look at the wisdom of forfeiture, even if it is available. So I'm just going to stop sharing my screen with you, and hopefully Will can pick up from there.
Hello, everyone, and thank you, Dan. Yes, I'm going to talk to you about the wisdom of forfeiture in this fundamentally changed economic climate. As most of you have doubtless gathered, it is not the remedy it once was. Its purpose was that if the landlord found himself in possession, or stuck with a tenant who didn't respect their covenants, be it as to rent or any other covenant, user or alterations, that he could simply say, right, well, I'm going to find a tenant who can, and therefore forfeiture was security against a defaulting tenant. It doesn't take a great stretch of the imagination to realise that nowadays it's going to be somewhat more difficult to find a replacement tenant, particularly if the premises are in the retail or shall we say restaurant sector. So if we move on to the next slide, the landlord needs to consider the market conditions. It's simply going to be very difficult, I imagine, in most cases, to exercise the remedy of forfeiture, which has the effect, of course, of depriving the landlord of any rental income in relation to the property once the forfeiture has actually been carried out. So there are a number of options to the landlord when it comes to managing its relationship with the tenant. As Dan referred to, it is, of course, open to the landlord to hold the tenant to their existing rental covenants. Nothing in the statutory regime which has come in the last few months affects the tenant's obligation to pay rent. There have been discussions as to space furlough, of course, and for an analogous furlough scheme which could apply to business premises, but regrettably for those business tenants, nothing of that nature has actually come through. So, of course, the tenant is still obliged, in theory, to pay the full rent in relation to the premises. It is, of course, open to the landlord, if it's feeling particularly benevolent, to make longer-term arrangements with the tenant. For example, a rent deferral or rent reduction. And if we move on to the next slide, please, or even a rent-free period. There are other arrangements that could be reached, such as the in exchange for no rent reduction or for the continued payment of rent, the waiver of the tenant-only break clause. So the landlord gives himself a longer time with that particular tenant. He gives himself a longer time with the benefit of the rental covenant. The rent may well be reduced, but it is nevertheless a means of preserving some form of income from the property. It is, of course, open to the landlord based on their particular financial circumstances, or maybe based upon the sector in which they operate, to decide for themselves whether it's best to take a financial hit in the hope of jam tomorrow, or whether they feel even confident of finding a replacement tenant. I imagine much will depend, as I say, on the sector in which the landlord is operating. If we move on to the next slide, please. As Dan alluded to earlier, there is no waiver that, pursuant to Section 82(2) of the Coronavirus Act, nothing that the landlord does operates as a waiver in respect of the covenant for non-payment of rent, unless it is express and in writing. It's important to emphasize that this operates only in respect of the covenant for non-payment of rent and doesn't apply in relation to the a waiver of a breach of covenant of any other nature, such as unlicensed alterations or unlawful subletting, that sort of thing. The purpose of it clearly is to allow landlord and tenant to negotiate along the lines that I suggested earlier. It's to give the landlord and tenant sort of breathing space to discuss and to come to some sort of practical arrangement. As Dan said at the beginning, the law of forfeiture is complex, and I think the Law Commission considered it labyrinthine and unfair in 2006. And as doubtless you'll all be aware, it is extremely easy to waive a covenant. So this measure, this legislative measure, just gives the parties an environment in which they can discuss matters in relation to rent more freely. If we move on to the next slide, please. Yes, this just summarizes some of the, well, all of the matters to which I've already referred. There is one more matter which I would like to discuss with you in more detail in relation to the no waiver provision. It doesn't necessarily mean, and of course this is yet to be tested in the courts, it doesn't necessarily mean that by entering into negotiations with the tenant as to the payment of rent, and should the landlord receive rent, it doesn't mean that that won't operate as a waiver of any other breach of covenant. So, for example, you may have a tenant who is behind on their rent and it is also in breach of the covenant against alterations. It's suggested that the proper course of action, if you wish to preserve your right to forfeit in relation to the alterations, it's suggested that the landlord serve his 146 notice, allow a reasonable time to elapse for the remedy of the breach, and then to serve proceedings. And as a matter of law, the lease will be forfeit, and then it will then be open to the landlord to discuss with the tenant the payment of rent, but strictly in the context of a possible relief from forfeiture. So it's considered that that is the practical means of avoiding the potential pitfall presented by Section 82(2) of the Coronavirus Act 2020. If we move on to the next slide. In order to constitute, for an act to constitute a waiver, it needs to be so unequivocal that when considered objectively, it could only be regarded as being consistent with the lease continuing. And that was stated in Greenwood Reversions Limited and World Entertainment Foundation Limited. If we move on to the next slide, please. The act needs to be unequivocal. The landlord needs to have knowledge of the breach, and it can also be the knowledge of his agent. For example, a solicitor or I imagine an estate agent or a property manager or something of that nature. But what needs to be established is that if the agent has knowledge of the breach, that isn't sufficient in and of itself. The agent needs to be an agent of a nature, of a character, in which there is an obligation to report to the landlord that there has been a breach. And in order for the right of forfeiture to be exercised, of course, there needs to be a determination under various schemes. There is Section 81 of the Housing Act 1996 in relation to the payment of service charges. There are 168 determinations, Section 1682 of the Common Hold and Leasehold Reform Act 2002 in relation to other breaches of long leases. And then, of course, in the residential context, and then of course there is the Section 146 notice, which is required for breaches of business tenancies and in fact other tenancies on some occasions in relation to breaches except the non-payment of rent, which is exempt from the requirements of Section 146 pursuant to Section 146 subsection 10. If we move on to the next slide, please. The question of waiver in the context of determinations was considered in the case of Stemp and 6 Ladbroke Gardens relatively recently in 2018. The breach was the failure to pay service charges, which were expressly reserved as rent under the lease in a long residential lease. The landlord very sensibly went off and got a determination in the FTT. The FTT determined that that all sums were due in relation to the service charges / major works. That was in December 2016. After that, the landlord sent a number of letters to the defaulting leaseholder and to all other leaseholders in the following terms, addressing them as dear leaseholders. We are carrying out works under the lease. We need to arrange for access and payment. This wasn't the only thing that the unfortunate landlord did. They also served a further demand for service charges upon the tenant in March of the following year, so March 2017. The landlord brought proceedings for forfeiture, and the tenant sought to defend them on the basis that the landlord had waived its right to forfeit based on the conduct that I have just described. The landlord sought to defend the allegations of waiver on the basis that one cannot waive a breach of covenant before the right to forfeit has arisen. And the right to forfeit, it was argued, only arises upon the determination of the FTT. Unfortunately for the landlord, that argument was rejected. If we can move on to the next slide, please. There is a quotation from the judgment in Stemp, which I won't read out in full. Essentially, in Stemp, it was decided that one is able to waive the right to forfeit prior to a determination under Section 168, or indeed a determination, I imagine, under any other provision of any other act. The matter was due to go to the Court of Appeal, and I was actually quite looking forward to it doing so, because I have some significant degree of sympathy with the landlord's argument if one looks closely at the wording of Section 168. It refers to a right to forfeit. And as a matter of logic, I would say that the right hasn't arisen prior to the determination. However, it was due to go to the Court of Appeal, but regrettably the matter settled in October. I understand between the parties. I don't want to brag, but I once persuaded a judge in the Justice Centre of Havant, which I believe to be round the back of a Nando's of the contrary position, and that was certainly a high point of my career. I would point out finally that in relation to Stemp, that in relation to a remediable breach, it would still be open to the landlord to accept rent, for example, during the currency of the Section 146 notice. and that is set out in the final paragraph of that slide. However, my practical advice, if you're ever faced with a similar situation, is simply, if the landlord or if one's client is absolutely dead set on forfeiture, if the landlord is possibly able to financially, simply to put a stop on the rent account and to instruct all agents or employees that may be engaged in those services under no circumstances to accept any rent. It simply simplifies the position. Of course, other barristers may have a different view, but that is mine. If we now move on to the next slide, please. On the assumption that the landlord has managed to avoid all the pitfalls presented by the law of forfeiture generally, and in this new economic environment, it is of course then open to the tenant to seek relief, and it is this that Dan is now going to talk to you about.
Yes. So dealing with questions of relief. Firstly, can you make an application for relief at the moment? Well, in existing proceedings, it would seem not. They're Part 55 proceedings for possession. That would be the existing proceedings, and of course, as we know, they're stayed. What about freestanding proceedings? They're Part 55 proceedings as well, or freestanding application. That's a Part 55 application. However, it's not for possession. And so my view is that it wouldn't be caught by PD 51Z. But what if they're already possession proceedings and the tenant wants to make an application for relief? Can it make a freestanding application not within the existing proceedings? Possibly an abuse? My view is that it's unlikely, given that they can't actually access those proceedings at the moment, given the imposition of Part 51Z. So, what sort of applications for relief can be made? In relation to rent arrears in the county court, you have section 138 to 9, and that also gives rise to the query under section 1382. Section 1382 of the County Courts Act 1984, which deals with relief from forfeiture, says you get automatic relief if you pay all arrears and costs at least 5 days before the hearing. So this will be in the context of possession proceedings, which have been stayed. But given that the relief is automatic under section 1382, it would seem that a tenant can automatically get relief by paying to the landlord all arrears and costs. Quite how the parties then go on and deal with the proceedings at that point in time is another matter. They may well have to wait until the stay has lifted. In the High Court, it's under the Senior Courts Act. For rent, for non-rent, section 146 of the Law of Property Act deals with relief from forfeiture, and the High Court has an inherent jurisdiction in any event to grant relief from forfeiture. And of course, it depends on whether the forfeiture has been enforced, has taken place by court or by peaceable re-entry. And I just want to have a look at a couple of cases now on applications for relief, with which the time that the application has been made has been significant as to whether or not relief was granted, and then just have a quick look as to whether that might have changed in light of recent events. So the first case is Pineport, and that was in 2016. That was a case where the High Court was asked to exercise its inherent jurisdiction to grant relief from forfeiture, which had been exercised on the grounds of rent arrears. So just to give you a few of the pertinent facts, 24th of April 2014, the premises or the lease was forfeited by peaceable re-entry for unpaid rent. 23rd of June 2015, the application for relief was made. That was 14 months later. In the meantime, there had been some illegal activity on the premises, but it's also notable that a premium had been paid for the lease. The Chief Master allowed relief. He said that the discretion is a broad one, not constrained by a fixed time limit in relation to whether to grant relief or not. And there are a number of factors that he set out in his judgment as to why he was going to grant relief. And he referred to the concept of bringing an application for relief with reasonable promptitude and said that that was an elastic concept. And then he recognised that 14 months was quite an exceptional period of time, more than double the guide period of 6 months, and near the breaking point of the concept's elasticity, but he was satisfied that it would be wrong to bar the claimant from obtaining relief. So there we have a case where it was possible after 14 months to bring an application because there were some personal circumstances, but it was still held. There was a discretion there. We then roll on to Gibbs in the Court of Appeal. And just to give you some of the chronology there so you can put this into context, 2009, September 2009, there was a claim for arrears. There's no response to that and judgment in default was given. In November 2009, then possession proceedings were brought for forfeiture on the basis of that judgment in default. And in February 2010, there was a possession order. Possession was physically obtained on that possession order in April 2010. In June 2011, the property was marketed for sale. In July 2011, the tenant or the ex-tenant who had became aware of all this, she'd been in Hong Kong at this point in time, had only recently become aware of the difficulties with the lease. In October 2011, then, 1 year, 6 months later after possession, an application for relief was made, and an application to set aside the possession order. And then by December 2011, just to add further complication to the facts, a new lease was granted of the premises to a third party. Here's what the Court of Appeal said, and the reference here to the Chief Master is a reference to the Pineport case that I've just dealt with in the concept of the elasticity of reasonable promptitude. And here, the Court of Appeal held that had snapped. And indeed, it was said that, in my judgment, even if the judgment for possession had been set aside, it would have done Miss Gibbs little good in circumstances in which her application to set aside the judgment was made 1.5 years after the landlords recovered possession. And this was very much seen as narrowing the scope for getting relief from forfeiture after 6 months, let alone sort of any other periods, and pushing back on the sort of slightly greater latitude that had been given by Pineport. Well, that leads to the consideration, will any more latitude be given now as to the timing of an application for relief from forfeiture, given the pandemic and given the general freeze on matters that is operating in the courts? As I've set out, it is possible to make an application, I think, for relief from forfeiture, albeit a freestanding one. However, it's unlikely to get on for a while, and for a number of reasons. People might not be going to premises, they may not be aware of proceedings that have occurred, or of any peaceable re-entry. I suggest that those are probably going to provide circumstances in which courts would look more generously on relief from forfeiture applications. So thank you all for watching. Now we've got some time for some question and answers. I'm going to hand back over to Will, who might pick up on the first of those. I think Will is muted at the moment. Oh, he's still muted.
Am I back?
You're back. Welcome back, Will.
How exciting, thank you. Somebody has mentioned Hackney and Okoro, and of course it's right that the stay under PD 51Z applies to appeals in relation to Part 55 proceedings as well. The question wasn't a question as such, but whoever that was right to mention it. The question was of course dealt with very shortly by the Court of Appeal about 10 days ago or so, and practitioners ought to be aware that the fact that the hearing is an appeal is not sufficient to bring it outside the parameters of Practice Direction 51Z. There is a further question in relation to rent deposits in relation to the Corporate Insolvency Bill. And I'm afraid my confidence isn't sufficiently robust to answer that one, so I'm wondering if you might have a go at that one, Dan.
Okay, I think yes. Yes, well, I mean, of course, at the moment there's no problem with that because the bill hasn't come into force, so there's that can be relied on. I think the question is whether or not it's enforcing security, and I think if you've already got a deposit there, that probably isn't the enforcement of security. So heavily caveated, I would have thought that it wouldn't necessarily be court, although one might have to look at the terms of the deposit itself. We've also been asked where there's an excluded lease with an expiry date prior to the 30th of June 2020, is the tenant still under a duty to vacate the property in the expiry of the excluded lease? Well, I think at that point, the excluded lease, the fixed term would have come to an end and the tenant is effectively no longer a tenant and is just holding over. There's nothing to keep that tenancy going. So there is a duty to vacate. In terms of getting possession, though, and if you needed the courts to get possession, you're going to have difficulties with that, given the current difficulty in getting any hearing. It would be a Part 55 claim. It would be against trespassers, and there are some carve-outs for that under the in the practice direction. Although presumably you would know the trespasser's name, and I think the carve-out is only for persons unknown. So you wouldn't be able to bring proceedings, I think, for that. But in terms of a duty to vacate, yes, I think there would. Will, have you picked up on any that you'd like to deal with?
Yes, there's a question from Jane who asks how managing agents should approach sending routine correspondence to lessees who are in breach. Well, I suppose the Rolls-Royce course of action would be to address any correspondence to a tenant who is in breach simply by their name. It would be ideal if it could be avoided referring to them as lessees. But I recognise in a large block that sort of thing may not be practical. I need to emphasise that in STEMP, it wasn't the conduct of the landlord in sending a letter to the tenant addressing them as lessees, which was a decisive factor. In fact, the judge referred to that as, I think, as a mere convenience. The decisive point in STEMP was that the rent had been demanded by the landlord. That was the act that had constituted the waiver. It's settled law that the demand, and particularly the acceptance of rent, will operate as a waiver, but in relation to other acts of the landlord, the court is free to look at all the circumstances of the case in order to determine whether there is an act so equivocal, as I referred to earlier in the presentation, which would constitute a waiver. Therefore, I would cautiously suggest that, depending on the facts, a letter addressed to a leaseholder, inverted commas, who the landlord considered to be in default, would not be sufficient to operate as a waiver. Although in an ideal world, as I've said, you would avoid referring to the lease and you would avoid referring to them as leaseholders. But I wouldn't suggest that it was the absolute end of the world if you did. Do you have anything to add to that, Dan?
No, I think that's a very, very comprehensive response, Will. Thanks. And Abby has asked, where forfeiture proceedings are currently stayed and the tenant has paid all arrears, can the landlord solicitors request mean profits and costs to be paid and then ask the tenant to ask the court to order relief under section 1382? That's what I was touching on earlier. Or do we still need to wait for lifting of the stay? Landlord and tenant want to regularise the position, would prefer the leases to be reinstated and there to be no uncertainty over mean profits which are mounting up. Yes, I mean, it's a rather perverse position I think we're going to find ourselves in is that there's going to be hesitancy and difficulty where landlord and tenant actually want to carry on with the lease rather than get rid of it, in that because of the stay, the parties are going to find it difficult to come back to court in order to lift the stay, reinstate the lease, or to put into effect any terms for relief that they've agreed. But in these circumstances, 1382, and I had a look at this before the seminar, 1382 says that if the lessee pays into court or to the lessor not less than 5 clear days before the return day, all the rent in arrear and the costs of the action shall cease, and the lessee shall hold the land according to the lease without any new lease. So it would seem that you don't have to go back to court. Once that's paid, the lease is automatically reinstated, so therefore you avoid the need of delving into to court or going back to court when everything has been stayed. How are we doing now for anything else you want to? We're running up now, I think, against the end. I don't know, Will, if you want to take another question.
I can't see any further questions, although that may be my software as opposed to their absence.
Okay, well, I think maybe we'll we'll leave it at that. Thank you all for watching. A reminder that you can send in any questions or feedback, which will be gratefully received at events@tanfieldchambers.co.uk. Don't forget, next week, Mark Loveday and Gemma de Cordova on 54 Act opposition grounds, and a recording will be available of this webinar, should you want to watch it again. I know will be, under the webinar section on our website. Thank you very much for watching. Bye-bye.
Thank you all.